right. So thank you everyone for being here. We're recording this. So if you miss anything, you will get the replay. But I want to welcome you and introduce Kim Williams, who is an amazing advocate for our work. She's done a lot with earned media, getting businesses on board. She's just done so much for our movement. So we're here for how employers deflect responsibility for safe work environments. And I want to read a little bit of the description and Kim's background. So employers sidestep accountability for creating safe and respectful workplaces, from systemic flaws to behind-the-scenes maneuvers. This session will provide invaluable insights into the challenges workers face in holding organizations accountable. Kim's a seasoned advocate and expert in workplace justice and will explore the hidden dynamics that shape workplace safety or the lack thereof. She will discuss how laws governing workplace safety are created, implemented, and enforced, the backdoor conversations and strategies that occur at the highest levels of organizations to deflect responsibility, and practical advice for navigating and protecting yourself within a system that often prioritizes profit over people. So Kim is the VP of People, Culture, and Compliance with Walker Advertising, and she's our spokesperson for End Workplace Abuse. She's appeared on nearly 60 podcasts and has been featured in NASDAQ, U.S. News and World Report, the Ritz Herald, and Entrepreneur. So welcome, Kim. We just for a little housekeeping, you can use the chat to chat with each other, but if you have a specific question for Kim at the end of her presentation, if you want to add your questions to the Q&A tab at the bottom of the screen, I'll go, anything that pertains to her talk will address Kim directly at the end of the presentation. So I'll hand it over to you, Kim. Thank you.
No, thank you so much. I'm really glad to be here. Really glad to be part of everything End Workplace Abuse is doing. Just to give you a little bit of context too on how I kind of landed here. Like a lot of folks, I went through a pretty tough experience with workplace abuse, but my situation was a little bit unique in the sense that, I was an HR chief when I was dealing with this. And I was the target of a chief executive. And so for me, I think it was kind of surprising in a couple of ways, given the fact that I felt like I had a really strong grasp of the rules. I knew how things were supposed to work, how they didn't work. I knew where all the bodies were buried. I knew all the maneuvers. And so had felt like I was someone who could potentially navigate an environment, and when I brought a complaint forward, that it be taken seriously, pretty much the same way I had always taken other folks seriously when they came to me. And instead that didn't happen. I couldn't open an investigation because I couldn't ask my own staff to investigate a complaint where I was the complainant. It would appear biased or tainted. So usually if you can't go to HR in your organization, you go to the lawyers, you go to inside counsel if your organization has that. And I did, and it basically said, oh no, this person is really scary. We don't want to deal with this. You're going to have to go to the board. And so I met alone with the board and said, you have a very serious problem. This person isn't just targeting me, but they're targeting women. You're looking at a discrimination claim. You're looking at something very serious. And in the end, I had some board members who were sympathetic. The majority were not. And then one of them went out and told the chief executive. So when I walked into my next one-on-one, it was like walking into a buzzsaw. And so at that moment, I realized that, I was pretty on my own with all of this. And I learned some things from that process. One, I for the first time in my life, I started Googling, like, what do you do if somebody's bullying you at work? And I learned that all the advice out there is absolutely hideous. It is absolutely atrocious. And so I want to spend a little bit of time today too, talking about some actual things you can do that would be more helpful than, find a hobby or meditate. But I also learned what to do when we kind of ran out of rules and we hit an end of a road kind of scenario. And I learned how to take some risk, how to stand up to my, abuser, how to stand up to the people who were too paralyzed with fear to do anything, and how to begin making a case on why they needed to act. And in the end, filing a lawsuit and negotiating something that worked out well because of the things I had figured out. And so I'm hoping to share a bit about that with you today. But first, I kind of want to run through some of the common patterns that we tend to see. First and foremost, I think we see a lot of punching down when it comes to the bullying space. And a lot of times what people will hear that, they're just kind of dismissed. You see gaslighting. Oh, you're being too sensitive. People will start to question whether you're a good cultural fit, as if you're the problem. And what I have found is that in 99% of those times, it's about fear. It's about a manager. It's about HR personnel. It's even about chief executives that are too afraid to address the problem. And it's just so much easier to try and get the complainant to go away, especially given that they know that the complainant's probably already afraid because there's so much evidence of retaliation. There's so many things that can have a chilling effect already on people that this is kind of an easy out. Same here, like a little bit of an extension of that, talking about a personality clash. And I categorize a little bit different because sometimes we'll see this as dismissive where they're like, oh, these two folks aren't getting along, while ignoring kind of significant details like one's an executive and one's not. And therefore you have very different kind of power dynamics and patterns of harm. And so, by trying to minimize these types of behavior with language that is minimizing, they're hoping to get out of having to do the hard thing and having a hard conversation. Policies too. I've seen where people lean on and abuse policies. And so in some ways, like on its face, it can even be kind of comical. Like, well, we created an anti-bullying policy as if that's the end of the road. And so they want to be able to point to something tangible to say, hey, we're compliant, or that we follow the law. I track a lot of news stories that deal with bullying, abuse, discrimination, harassment, and you'll frequently hear lines from companies where when they're defending themselves from an accusation for something like this, they tend to say, we follow to the letter of the law, we're compliant with the law. All those things mean we do the bare minimum, which is usually not enough to protect somebody from harm. And so simply having policies can be used to deflect. Pushing responsibility onto HR or management. We'll get into this a little bit later too, because I want to kind of give a backdoor perspective of what it can be like in HR, how often that they deal with a lot of punching down themselves. But a lot of times if you have a high level leader who is pushing off a bully or a problem child onto HR managers, it can become problematic because in some cases, managers just aren't trained for how to deal with this. In some cases, HR is only trained to deal with things up to a certain point. A lot of times they're not empowered to deal with executives. And so by delegating to them can actually make things worse. Using confidentiality to silence folks. So hiding behind policies to avoid transparency. To be clear on this one, anytime that there's an investigation into discrimination, harassment, any kind of violation of a policy for the workforce, there has to be some degree of confidentiality. We like to try and say that, we'll protect confidentiality as much as possible. That's not always 100% possible. A lot of times if I'm interviewing someone and I'm letting know the complaints come up against them, through my line of questioning, they are going to be able a lot of times to piece together things in terms of who may have said something or who may be involved in a process. So we can't guarantee things completely, but we can also see where this can be an area of abuse where employers will hide behind confidentiality and they'll say, oh, the investigation is very confidential. We can't share with you what's going on. We can't share with you what's being done. And it's something just to kind of watch out for, because when a company is doing the right things, when they're really following up, yes, they're not going to violate confidentiality. They're going to do their best to protect kind of protected information and protect people's privacy, but you'll still know. You'll know that if you make a complaint and there's an investigation and that, someone everyone has seen behave in a bad way is no longer at the company. No one has to violate confidentiality for you to be able to sense that the company takes this stuff very seriously and they're holding bad actors accountable. We also see this too, I know Deb is super familiar with this. We see it in the legislative space. If it's not physical safety, then it doesn't exist. And we're seeing a lot of encouraging movement in terms of countering this. For anyone who's ever been bullied, it feels very, very real. Like your cortisol is pumping. We've seen people come to us and say, I have cancer. My doctor was very direct in saying that this was tied to workplace stress. We have suicides, some of them nationally known, whether it's depression, anxiety, broken marriages, ruined careers. None of this stuff is invisible when we talk about the impacts. And I know Deb has done some really great work with Dr. Jen Frazier, who even talks about how workplace abuse can leave scars on the brain. So a lot of what is psychological can actually be very, very physical, very, very tangible, and very real. But a lot of employers, out of a fear of dealing with a tough situation or a risky situation, will hide behind that in order to avoid any kind of liability or accountability. Toking training programs. I know pretty much everyone in HR world is a big fan of SHRM, is really well connected with SHRM. I've spoken at a number of events. I know a lot of people who are part of this network and are very, very happy with it. I've actually had some concerns with the heavy leaning on training programs because I feel like they only work to a point, and then there's not a lot of conversation or training or support for HR folks beyond that. And so if we know we have a tough climate, if we know we've got a toxic work environment, and all the trainings are geared towards, like right now, their current campaign is around civility, how to be nice, how to work better with others. But if your CEO or another executive who happens to be the big problem person refuses to take that, there's not a lot more we can do there, and that can actually send a worse message to folks when they're not doing that. Yeah, I'm sorry to hear that. I do believe that. Unfortunately, I have seen where SHRM is not just against legislation, but against a lot of accountability. I think a lot of it has to do with their ties with larger corporations and big businesses that, they really place HR in a not very empowered role, in my opinion. For me, I didn't learn about HR and SHRM. I actually learned about it at the State Department, where we had to deal with very big Washington egos. We had to deal with ambassadors. And so it was baked into our training that we had to learn how to manage up. And so that's one of the things that I see, that trainings can become a tangible thing that we point to say, oh, we've done this. We can pat ourselves on the back and we're good now and we don't need to do anything further. And that, of course, can be a problem. So retaliation and fear, for a lot of folks, you can look at news, you can hear stories, you can see examples of folks who've spoken up about problematic, environments, and then they were essentially mobbed or chilled out of an environment, retaliated against, put on a PIP. There's so many of these stories out there that a lot of employees are having to work through fear just to kind of raise their hand and point out that there's a problem. And so in many cases, employers are relying on that. They're relying on that silence. They're relying on that fear, or they're relying on a whispered conversation offline saying, do you really want to do this? This is going to be tough. I know this was unfair, what happened to you, but nothing is probably going to happen. And as a result, there's never anything put in writing. There's never a record of a complaint. And so then they can kind of lean on, well, nobody came forward and said anything, and it kind of gives them an out. Wellness initiatives are another one that can be a form of gaslighting. I've seen a lot of this over the last 2 years, where there's so much focus on employee burnout and stress without addressing the core part of the problem, which could be someone who's screaming at everyone all day long. And so these can be another way where they're addressing a surface level problem or, checking a box and saying, oh, we're doing these things to try and help morale, even though a lot of folks know that that's really not the source of the problem and they're really not going to be able to fix it through that. Investigations. We'll talk about this a little bit in a minute too. But in my particular case, I knew I was by law, I was entitled to a timely, objective, thorough investigation, and I had to demand it repeatedly in order to get one. And so a lot of times they'll slow roll the process, hoping that people will just kind of give up and go away, trying to say, oh, there's not a basis for one. A lot of times that's completely false. And so all that's done, to protect the organization. But again, a lot of it just comes out to good old fashioned fear of there's this really mean, tough person out there that folks don't necessarily want to deal with. And so all of those things, you'll see some common threads that we're kind of looking at. Fear can be pretty much tied to all of it. And then there's these kind of structural components that are put in place that don't force accountability, don't force, any type of hard conversation, that don't really force action. And so I've added this image to the slide deck. The fish rots from the head down, in part because if you're dealing with a bad environment, it absolutely comes from the top. We talk about this a lot in an HR context, that they tend to be a direct reflection of the CEO. So if your HR person is weak, somebody wants it that way. And so if you have a bully executive, a bully chief executive, a lot of times when they're vetting HR chiefs, and I'm pretty sure this even happened to me, that they looked at me in that particular case and said, oh, here's a nice, like, soft-spoken lady with a Southern accent. I don't present as someone who would challenge folks or engage in direct conflict or any of those types of things. And so I do feel like that was the assumption that was made, and that they were quite surprised when I came back and said, no, this isn't okay, and we can't necessarily do this. And so there's nothing bully bosses love more than kind of weak managers who won't hold them accountable. And so that even kind of gets a little bit structural by design. And so right now, like the company I work with, the inverse can absolutely be true. After going through my own workplace abuse scenario, I wanted to work for a company that had integrity. And so I was very open and honest when I was going through my interview process, saying I came from a very toxic environment. It was not a high integrity environment. It was not a place where I felt like I could work because there wasn't accountability where we needed it. And in some cases, I would lose interviews. I'd be told not to call back anymore. And I was fine with that because that told me everything I wanted to know about the company. But when I got to my current company, where I've been for 3.5 years, everyone in the interview chain had shared a similar story where they had been abused and they wanted to downgrade their career. And when I talked to the CEO, I could tell that he was a person of integrity, and he still is. Part of the reason why I can go out there and write articles about how to sue your boss, and I can teach people how to sue their boss, is because I know that he trusts me and we have built that relationship. So when I come to him and I say there's a problem, that he has my back and that we will take care of these things. And it doesn't have to be a policy. It doesn't have to be a law. If I know that someone is harmed, you will get a call from me as the VP. I will dig into this. I will investigate it. I will follow up, and people know that that will happen. And so there's a lot more trust and good faith in the process that we've established from that. And so all those things are really kind of well in sync. When I mentioned before that I want to talk a little bit about HR, because so often that is not the case. And so on closed groups and LinkedIn and other places, you'll hear a lot of HR professionals who are dealing with enormous abuse themselves. A lot of them have their own horror stories where they're struggling or they're trying to advocate for others, and they're either getting pushed out of the process, retaliated against. It's not uncommon if it looks like there's lawsuit potential for executives to rip it out of HR's hands altogether and farm it out to outside counsel and completely shut them out of the process. And then when it's time to deliver bad news, they'll hand it back over and say, go form the employee. And they really haven't been included kind of a lot of the time. A lot of the training that goes on with HR, like we mentioned with SHRM, I've had some concerns with that, given the fact that, to me, if we're ever going to really address or eradicate bullying in workplaces, you have to be focused on the executive level. It's where most of the abuse takes place, and it's where most of the avoidance takes place. It's also where we lack accountability, because a lot of times those who write the rules, they write them differently for themselves. And so this is why you end up seeing a two-tiered system in a lot of companies, where if a janitor or an hourly employee violates the policy, they'll throw the book at this person and fire them on the spot. But if a chief revenue officer, a top engineer, a family member, or someone else at a very high level does 10 times worse than this, they'll get them an executive coach, or they'll do something much softer, and they'll lean really heavily into what can we do to meet a bare minimum kind of standard from there. So with all of that background, I kind of want to share like what you're up against from the other side, and then start getting into a framework that I established about a year ago to really help you navigate a space like that with some of that understanding. And I call it the Fear Not framework. I have to give credit to an amazing lady, Denise Conroy, who helped me come up with this. I also got the, rotten fish scenario from her. She was the one who had identified that some time ago. But it became kind of an easy way to learn a formula that I have figured out that through my own process and through the process of helping other people either find a resolution, get a bully fired, or find an exit and a decent exit package with that, has really followed a pretty straightforward plan that I wanted to take a minute and kind of go through with you now. Number one is fear. And I think a lot of people kind of dismiss this of, yeah, it's fear, but it's actually the most critical piece of this entire framework, because I watch people constantly succumb to the fear. And it's a very real, very intense fear. When our jobs are on the line, our whole life can feel like it's on the line. And so getting a handle on that, treating it like the life-threatening emergency that it can be, is really, really critical, because the more you can show up with calm, or at least the expression of calm, no matter how you may be feeling on the inside, the more powerful and the more you're gonna show up, and the more you're gonna make other folks afraid. Because all of this stuff is not just the words you use, but there's so many signals that HR is taught by outside law firms in terms of what to look for and how we use leverage, and whether someone is someone we want to be afraid of or not afraid of. And if they're not afraid of you, you're not going to get very, very far. You're going to show up in a weaker position, and all those horrible things that we talked about and how they deflect and what they use as excuses are going to come to bear more fully. And so when we talk about managing fear, this is really getting at the heart of that cortisol that can start to pump through our whole system. And so that's what's keeping us from sleeping at night. It's keeping us from eating. It keeps us in that place where we're kind of playing back the cruel scenario, the humiliating conversation over and over again. It's that space where we're in the what ifs, and if I lose my job, what's going to happen to my family? What's going to happen to these? That can really drain your energy in a way that's important to combat. And so, for me, I needed to burn that off on an elliptical machine. Some people find calming things really helping. I actually talked to one person who started knitting, and there's a lot of science behind that it lowers cortisol. Anything that does that, yoga can do this. You can find videos online. Restorative yoga in particular is designed to suppress the sympathetic nervous system. I don't say that correctly, but it's good. I know that was one of the things that really, really helped me show up in a way that I needed to. And then I think it's also important to remember that, standing up to your boss, it can be a terrifying space, even if you're doing all of these things to try and help keep your calm and keep your cortisol down. And that's okay. I know for me, I had some really intense, terrifying moments when I realized that the board wasn't going to do anything, when I realized after my meeting with the board and the chief executive very directly threatened me, said that, anyone that's ever complained has had their careers destroyed, knew that they were protected, was gleeful about it. And so I was definitely afraid. I was a single mom and I was terrified. And when I finally sat down and wrote out a letter documenting everything that had happened with council, with the board, saying what all of you have done is wrong, what all of you has done is unlawful, what all of you have done is in violation of policy. It's things where you have lied, things where you've done all these things. And my hands were shaking the entire time I drafted this email. And I always tell this story because it's a-okay to be feeling that way, where I was so afraid to even hit send on that email that I saved it as a draft. I went out, I got my car, I was driving out of the parking lot very late that evening. Nobody was even there. And I still just like hit send from my phone after I had driven away from work in order to get that out. And it was what I needed to do to get through that moment. And if you need to do things to get through that moment, it is a-okay. So when we look at whatever we need to do to manage fear, then we can start getting into the space where we're actually beginning to take action. And so if fear is the first part of the fear not framework, evidence, the E is for evidence, is the second really, really important piece to this. I'm an HR person who's built my career on standing up for folks. I do what's right even when my job's on the line, and I definitely have had my job threatened. But I've also run into complainants who were so overcome with fear that they couldn't kind of piece together a story that was really helpful for themselves. They didn't have all the facts together. It was kind of, I remember one incident where someone had sent me like a 20-page email, and it was heartbreaking to read. And it was all about these feelings and this fear, but there were no facts in there. There was no supporting evidence. It was clearly a person who had been run through the ringer for so long that they kind of couldn't take it anymore. And then everything just kind of poured out of them. If you really want to influence the backdoor conversation that's taking place between HR managers and the top of an organization, then you really want to get this piece right. And it's not that hard to do. For me, as soon as I run into an issue, so if I'm in HR and I see an employee and I see that there's a potential problem, or I see that somebody may be coming after me, I will go ahead and set up a document, and I'll just start doing very, very simple facts. In this context, for most of you, I actually recommend that you do it on a Google Doc at home, nothing on your work computer, but that you start a very simple timeline. And so the first time there's an incident, you want to note that it was March 26th at 7 p.m. I was on this conference call with, Bob, Susie, and Tariq, and Bob did this terrible thing. And you don't have to put in a lot of detail. In fact, you don't want to give any color. You want it to be very much just the facts. If there's any supporting evidence at all that you can tie to that, records of a team's conversation, the calendar invite, if there's a transcript of the call, I know some of those things have that now. Be careful with that and make sure that's something everybody consents to. Then you want to be able to pull that aside in a second document that runs counter to your timeline, so there's supporting evidence for anything that you say. When you're dealing with getting things off work computers, you of course want to be very careful. You want to make sure that nothing is sensitive or proprietary. Sometimes it's good too to not just simply forward things to yourself, but to use a phone or a partner's phone, take pictures of screens. I actually trained somebody that if they were in an environment where they're not near a computer, to text themselves like a short code for something happening so that when they go back to their timeline, that they can very quickly use that as a timestamp reference that this thing happened. And you begin just piecing that together and adding to that, and just to show, a fact pattern. These are the things that happen. And you want to do this really no matter what, whether you go on to file a formal complaint or not, having some form of evidence in case there's a bad event is going to be very helpful in a moment like that. When I first started doing this, and when this happened to me, we didn't have AI or chat GPT, but it is certainly worth considering doing something like that where, if you have those kinds of tools, just to throw a timeline in there and ask it, pretend like you're an investigator. Is this devoid of feelings? Is this, how would they present this? Are there any edits that you would make? Deb and I actually recently came across a great website that I'll show here is hively.com. I haven't played around with it too much, but I'm really fascinated with it just because it's free and it basically lets you speak to it and it will help you document your case. So I was very excited to see something like this exist. And certainly, I recommend piecing something like that together because it'll let you download it as a PDF. It will even guide you and talk to you about what the local laws are, which can be very, very helpful. So definitely looks like a good tool to check out if you don't want to go with the chat GPT route. Another thing that's really helpful with evidence is to get out your handbook. No one ever looks at their handbook, but when you get into lawsuit territory or violations and investigations, it's actually very, very important because a lot of times your handbook actually will speak to bullying, harassment, discrimination, and it will state in there, we will conduct an investigation, a thorough and impartial investigation, or they'll set timeframes for when they do that. They have rules for how you're supposed to communicate, who you can communicate with. And so just like that is meant to be a contract with you, it's also a contract with the employer. And we've seen lawsuits that have been very successful for employees to go after employers for failing to follow their own handbook because it was deemed a breach of contract. And so getting some familiarity with law, you don't have to become a huge expert, but just very obvious things. If it's a discrimination case and someone's made a derogatory remark about, race or gender or ethnicity or some protected characteristics, well, that's clearly an unlawful situation. And then if there's anything specific in the policy, you definitely want to take note of that as well. So number 3 is articulating your case. And by now, if you've done steps 1 and 2, you'll be well positioned to do this because the absolute best thing you can do if you want to make the hair on the back of someone in HR's neck stand up is to carefully, calmly, professionally, in writing, make a complaint. And to do it with the understanding that you're not speaking to HR, you're not speaking to a manager, you're not speaking to the bully, you were literally speaking to a juror. Because when an outside law firm assesses the weight of your case, they are thinking about how you would present outside the company walls. How would you present in the media? How would you present at a jury trial? And it doesn't mean that this will go all the way to a jury trial, but a lot of people on this side of the equation are thinking about that because if they think you'll come unglued, they're not going to take you seriously. If they think that you'll show up as strong and credible, they're going to get nervous and it changes how they respond to you. And so they're going to be far more serious. They're going to be far faster with an investigation. If you're getting into a settlement and a payout, the numbers can absolutely go up depending on how you show up there. So it's a really powerful leverage point. And when you go to articulate your case, a lot of times it's nothing more than a very simple email where you're pulling from your timeline, not the entire thing, but a few key pieces that are particularly strong to say X, Y, and Z happened to me. I believe these are policy violations. I believe this violates EEO law. Very, very simple, just the facts, very calm, very professional. And then you end with, and this is impairing my ability to do my job. That's it. You hit send on that. You let them stew on that. You let them freak out about that. You let them respond to you after that. Now, at this point, we come to number 4. So we're, the R in fear not is the resolve and maintaining your composure, because things tend not to move very quickly once a complaint has been filed. And it can feel like thousands of years go by every single day while you're waiting for a response from the company, while you're trying to figure out what the next steps are going to be. As word begins to seep out that you may have filed a complaint and people get nervous around you. And so it's a little bit different than the initial fear that we had when we began to look at a process like this. But you definitely want to make sure that you're maintaining whatever you have figured out to keep that cortisol down, to keep your energy up. If you need to start applying for jobs just to make yourself feel better and more secure, do that. Do not stop with your timeline. The email that you sent will be another piece of evidence. If anyone it gives you the side eye afterwards, that goes in the timeline, because anything in that fact pattern could look retaliatory on the company's part. Next, how are we doing on time? Okay, I'm going to start speeding through this a little bit faster. Navigating an investigation and understanding your rights there. Definitely be familiar with whatever is written into your handbook, from the standpoint that, like if you're a member of a union, you may be entitled to have a representative there. Some places will allow you to bring a family member. If you're really particularly worried and at this stage you're comfortable reaching out to an attorney and presenting all the evidence that you've gathered up until that point, having someone represent you may be a possibility. But be sure to continue to keep documents during that time. If folks are coming to you telling you, oh, I just met with the investigator and they're sharing what happened, note it, put it down there. Do a good summary after you met with the investigator to try and keep details of what they asked you for. And then outcomes. So another the first O in not is pushing for a just outcome, because this really can get into a space that becomes more high stakes and that becomes more high risk for an employer. And so it's not uncommon, or what I've seen happen quite a bit, is a company will actually farm out an investigation to a law firm and have an investigator come in. And they're not doing that because they're bringing in a professional who's neutral. Odds are they're going to do a good investigation. Nobody's going to risk their bar license for another organization, but it does keep it under attorney-client privilege, so that whatever garbage comes out in the investigation is harder to get to. And then once that investigation is complete, they will farm it off to another law firm, again, to keep it confidential, who will draft up a summary statement, and they're paid to come up with every bare minimum thing that they can do in order to not be accountable. Because the more accountable they are, the bigger the potential payout, the more liability, and they're going to do everything they can to avoid that. And so this tends to show up in ways we talked about at the beginning. Oh, well, we have a policy in place, therefore we're compliant. Oh, well, we did training, so therefore we're compliant. And they're going to try and go for the softest, babyest things that they can potentially come up with. This can feel very, very disheartening for folks that are going through the process. But if there's one takeaway from this conversation, is that I hope folks don't necessarily feel that way, because one, if your own internal HR did the investigation and there's any mistakes or conflicts, or they did anything incorrectly, a good lawyer can tear it to shreds. There's also leverage in just having an investigation. I've seen a lot of folks, myself included, where at the conclusion of my investigation, they came back and in writing stated that they sustained allegations of abuse towards me, but that nothing unlawful happened, because I had made a claim based on gender, and I'm pretty certain that some men came forward. But at that moment, knowing that that investigation existed and there was a document, and buried within that document, it was a whole bunch of horrible things I knew that they did not want out into the world, I was able to get an attorney who asked for an agreement, asked for a settlement, and asked for a copy of that document. And I was able to negotiate from a very good place, far better than I would have if I had not gone through this entire process. And then last is talking about it. One of the beautiful things that has started from Deb and her work many years and in workplace abuse, and that I've even just seen over the last 2 years, is this used to be something no one spoke about. And now so many people are talking about it. It is in the news. It is in kind of the national public conversation. And the more we talk about these things, the more empowered all of us are. And it can also be, for me personally, it was very healing to be able to say these things out loud, to find the vocabulary that we could assign to this unique experience. The last thing I just wanted to cover quickly, because I did want to give folks some time for questions, is on the item in terms of like how we articulate and how, like our case, and how we get buy-in from the company to help us and to support us. And sometimes we need to feed that to HR if our HR shop is not incredibly empowered. And we can do this a couple different ways. A lot of the reasons why I follow news stories so often is because I can find two things typically in those news stories. One is a company that looks like the one where the bully's at. And two, the name of a law firm who's representing someone at the company who is very similar to the one that the bully's at. And that's really powerful. So say I'm working for the Kim Williams company, and there's this terrible bully who is, very, very sexist. And so somebody has come to the Kim Williams company and they're trying to complain to HR, and HR is not being very helpful. But that employee goes out and finds a news story about a company, same industry, same size, same exact type of jerk, that's just been sued for $50 million by Bob Smith's law firm. That's really helpful information, because that empowers that HR person to have a different kind of conversation with the boss that says, you may be afraid to deal with this jerk, you may not want to engage here, but there's some real money at stake for you and the company if you don't. We also see things like I mentioned before about contract violations. For public companies, we're seeing derivative suits where like shareholders are coming after boards if they knew that there was a toxic work environment, or they knew that there was sexual harassment or these other types of things, because when it gets into the press, there's an immediate hit on their investment, and they're now suing boards for things like that. And so there's a way to introduce accountability there. The quick talk videos that we see all the time that can reach, there was one case where it was a bully boss, absolutely horrible man at a construction site. I think it was in Arizona. The young lady filmed it. It got over 20 million views. It got national news coverage. It didn't just destroy his job, it destroyed the company. And so these types of things are far more real now. But one of the other things that I like to share with HR folks is how to calculate the exact cost of a brilliant jerk. Now, this slide, it gets into more HR focus. We're running 360 performance reviews, finding, an employee and a boss who thinks highly of themselves and their peers and subordinates don't think highly of them. You don't need a 360 process typically to know who your nightmares are. But what we did is we created a process that's now part of a lot of HRIS systems or human resource systems, where they can begin pulling salaries and then doing a return on investment for those salaries. So for example, if I won't say a brilliant jerk, but just a really big jerk, and it's a nightmare for those who work with me, and it's pure hell for those who report up to me. If everyone around me is a high performer in a happy, safe environment, they're probably giving a 90% return on the salary that I give them. So let's just say I'm a jerk and I'm a nightmare to work with. So my peers are not going to be able to give that 90% on, let's just say, $100,000 salary that they're getting. Their bare minimum, we can say conservative number, is they're losing about 30% of their productivity. They're either reeling because I've humiliated them, they're dealing with micromanaging, they're cleaning up, they're looking for other jobs, they're avoiding me, whatever it is, there's a real impact to that bottom line. If it's direct reports, you're probably looking at half. And so we actually came up with an automatic calculation that can pull someone that we think is a jerk and immediately calculate how much of a salary loss that company is taking because of this person's behavior. So in the example that we tested out with me, 2 peers, 3 direct reports, it was like $420,000 that the company was losing just because I'm this horrible person to work with. Now, you also don't have to have HR access to run this type of exercise. Plenty of places have, salaries online. You can go look at Glassdoor. You can get like a rough sketch of what folks are likely to be making. Or if you work with one job title and you're an analyst and everyone else is your peer, then you probably have some sense of what that they're making. And so there's ways to do some kind of back of the napkin calculations that can also be very powerful. And we've seen this get a lot of people's attention when you're able to show that this is so much bigger than just you and what you're going through, but it can hurt the entire organization. So, sorry, Deb, I thought I was going to do 30 minutes and I went on for too long. So if you want to take questions, I'm happy to.
That was great, Kim. Thank you so much. There is one question in the Q&A. If anyone else wants to add a question, feel free. I have a question that I just want to ask about the timing of that. I love that Fear Not framework, and I'm wondering if you have recommendations around. I mean, it sounds like you recommend going through or giving HR some evidence before you pull in a lawyer, but I'm just wondering what your thoughts are on pulling in a lawyer first before you do that, or just what kind of maybe the reasoning is, if anyone has concerns over like handing over their cards to HR before talking to a lawyer. Just
yeah, there's really no wrong answer there, but I have found, and part of the reason why I love that Hively website is from the employment lawyer's perspective, a lot of times they get what I kind of gave in that example about that person who was so full of feelings and it was a 20-minute thing. And so sometimes if we show up for an employment attorney and they're busy and we've got someone who is not structured, who isn't tight, who doesn't have their timeline together, it can be very problematic. So I would say you don't have to share that with HR, but prepare it and at least get all those details together. What I really liked a lot with that Hively is it downloaded it in a PDF format with the intention that you could share it with a lawyer. So you certainly could go to a lawyer first, but they are going to want to see, like, what direct evidence do you have? Like, is this going to be a tough case? Is this he said, she said, or is there anything there? And that way you can go to an attorney and sometimes they'll pick you up, sometimes they'll give you good advice and say, here's what I recommend that you do. My experience, though, is once you put the company on notice, the company's now liable. And it can make your case stronger to an attorney, but there really is no wrong answer. Like I always say, if in doubt, reach out and talk to someone. A lot of times they're social justice folks, typically on the plaintiff side. And so they'll be like, hey, you're not there yet. Do X, Y, and Z and can still help.
okay. Yeah, I was going to ask too about like the strengthening of the case if you do give HR the simple, yeah, we already answered.
Yeah, it definitely does. Or filing with the EEOC or your state agency. Anything that documents it is a more serious claim, that physical stuff. So they'll take that more seriously.
Okay.
Oh yeah, so handbooks, you follow whichever one helps you. So look at everything, because sometimes, yeah, you'll see that where there's like different handbooks on different things. Or I've seen a larger organization where they'll have ethics rules, or they'll have a separate IT policy that's not in the handbook. Anything that they put out that's official can be potentially used against them. It gets nuanced with the jurisdiction. And you're right, I definitely see the comment about EEOC. One thing I will say is before this administration and before all this stuff showed up, it wasn't that great. And it's no disrespect. I profoundly love the EOC. I know a lot of people who work there who've lost their careers that are amazing people, but it has never been well funded under any administration. And we would always see that like state agencies, yeah, very overloaded employees, very, and so, and I'm actually glad you raised this because you may be surprised about where you do find jurisdiction because like for me, I live in DC. I'm a remote worker. My company is based in California, and California will actually write rules that say if you work to the benefit of a California employer, you have a right to file a complaint in that state. And so if you're in Alabama, you want to file a complaint in California, not Alabama. And so jurisdictions vary widely, but we are seeing that trend in like Illinois, Colorado, New York, where they have the most robust laws that since the pandemic, they've started doing that. So you definitely want to look at that. And sometimes if you live in a big city, I'm now seeing that too, where cities will have protections that the state won't have. And yeah, but you know what? A lot of states are at will, like Texas, believe it or not, we see more things coming up out of there. I would say it's the top three states for the biggest lawsuits. You know, New York and California aren't surprising, but Texas is massive. And a lot of times what'll happen is you go into federal court or you go into these other jury trials. And they do understand this. So a lot of times in HR and in risk environments, we talk about how it's a very plaintiff-friendly environment. And that's part of the reason why people are focused on a jury trial. Because if it plays well at a jury trial, you'll see, I mean, I've seen one case in Texas, FedEx, one discrimination claim, and it was way over $300 million that they awarded the plaintiff. In part because most of the folks that sit on the jury are not CEOs, but they probably are someone who's been abused or been hurt by somebody, and so they tend to be far more sympathetic. Also important to remember too that like less than 10% of cases make it to trial, but everything is about that threat of trial. And so you'll hear that over and over again if you ever walk down this process of, oh, this person would present well at jury. You don't want this to go to a jury trial. This is what they're looking at jury. Settle for this smaller amount now. And so those can be there. But yeah, even in at-will state, you can have those contract violations. You could still have a workers' comp claim. There's so many more things now that attorneys are figuring out. The plaintiff's bar has become so much more creative in all of that. And Michelle, if you want to write me, I actually know a great employment attorney in Arizona. I don't know attorneys in every state, but I can. I'll put my LinkedIn here if anybody wants to reach out to me. If I know someone, I'll definitely try and help you.
Thanks, Kim. There's a couple questions in the Q&A. The first one is, from my experience, I made the mistake of advising senior employees that I took sick leave due to workplace bullying. When I returned to work, my boss made a formal complaint against me and I was moved and penalized with the bullies staying where they are. Do you agree that when I made a verbal complaint and not in the state of mind to put it in writing, there should be someone in HR to help us with that complaint?
Yeah, so jurisdictions vary widely. Definitely not a lawyer, so I want to throw that out there. But for me, and some of this is shaped by California law, as long as there is harm done, the company's on notice. It doesn't matter whether somebody even reports it directly, HR. If you say something to your manager, the company's on notice. And so you want to document as best you can that conversation. So like, it doesn't matter, even if it's not in writing, if you're able to pinpoint that, I spoke to that person on March 26th at 2 p.m. During our one-on-one session, that's already very, very helpful. Not everything's going to have a written record to it.
The next question, I'm not sure I understand it, but if we can ask clarification here, but I work in healthcare. Can you leverage contacting the Joint Commission if something or someone is not addressed, as the Joint Commission has a distinct anti-bullying statement on their website?
Maybe. I'm not as familiar with that one. I know healthcare is rampant with abuse. And so, one of the first things I would do is whatever state you're in, whatever jurisdiction you're in, Google news articles because they tend to do this more of a hospital that's been sued, and particularly a hospital that maybe, has bullying or whatever that is tied to that, and find those attorneys that sue hospitals. And it's a leverage point because the first thing that when somebody gets a complaint, like nobody likes getting a letter from a lawyer. But if I get a letter from a lawyer and I go Google them and it looks like someone just out of law school with like a one-page website, I'm not going to sweat that. If I open up their main page and it's like sued millions in hospitals, I'm going to be like, oh crap, that's a very different kind of conversation. So being mindful of that can be helpful.
Thanks, Kim. Does anyone have any other questions in the Q&A? We have a couple more minutes. If not, we can wrap up early, just a couple minutes early here. This was amazing, Kim. I think these suggestions were like, even from the beginning, everything's so spot on about how this works. I will send out the replay to everyone, and someone's asking where we can follow Kim. I'll make sure that her LinkedIn gets in that email too. But thank you so much. This was really helpful. And if anyone has any further questions, you can reach out to Kim directly. So thank you so much, Kim. This was
Yeah,
great.
no, thank you. Happy to help any way I can.
Thanks so much. Have a great night, everyone.
All right, you too.